Hello everybody, this is Janan Jara here to provide you with a video covering a legal topic. Today's topic is going to be adult child support. Quick introduction, my name is Janan Jara. I'm a lawyer practicing in Edmonton, Alberta. My areas of practice include divorce and family law, criminal law, and child welfare law. So I am making another video, finally. I know it's been a while, and today's topic is going to cover adult child support. This particular video is intended for informational purposes only. It's not meant to be legal advice. I can certainly provide you legal advice should you wish to do a consultation with me, but that'll only happen one-on-one, direct consult with me, then I can actually give you legal advice. But for the purposes of this video, it's for information only. So I know it might come to some parents' surprise that they may continue to have to pay child support even after their child turns 18. I know some of you might have thought and rejoiced at the fact that once my child turns 18, I'm done paying that child support payment. Well, don't celebrate just yet. In some cases, it'll end at 18, but there are cases that justify it going past the age of 18, and that's what this video is going to cover. So, adult child support. We're talking about child support for individuals that have already turned 18 and that are over the age of 18. There are two places one can look to find out the law surrounding adult child support. So if you filed any kind of application under the Divorce Act of Canada, you will get a different definition, slightly, than under the other act that child support is included in. In Alberta, it's called the Family Law Act. So I'm going to provide you information about what the Divorce Act says about adult child support and what the Family Law Act of Alberta says about adult child support. So let's start with the Divorce Act. So the Divorce Act is a federal piece of legislation. It covers essentially all of Canada and only applies to individuals that were in a marriage, meaning common law, people who live under common law rules or adult interdependent partnerships wouldn't pursue a claim under the under the Divorce Act. So the Divorce Act does define what a child of the marriage is. It's important to know what the definition of a child of the marriage is because it's only children of the marriage that would qualify for child support. So the definition under the Divorce Act for a child of the marriage is a person, a child, who's under their parents' charge but unable to, by reason of illness, disability, or other cause, to withdraw from their parents' charge or to obtain the necessaries of life. Let me maybe add a little bit more commentary to that. You'll notice in that definition that there is no specified end date. It doesn't say child support ends at age 23 or 24 or 25. Technically, there is no technical end date to child support pursuant to the Divorce Act. Now, before some of you parents start having difficulty with this or hyperventilating at the idea of having to pay child support past age 18, it's not automatic. You have to be able to show that the child is unable to withdraw from their parents' charge for the reasons that were outlined, like disability, illness, or another cause. And commonly that other cause, in my experience, is the child going to post-secondary. I've seen many parents justify and continue to receive child support for their adult children when their adult children are still under their charge and going to post-secondary education. Now, before anybody thinks, oh geez, my kid's going to be a professional student and want to, be in post-secondary for 10 years, am I going to have to pay child support, adult child support, into their late 20s and 30s? Rest assured, I have never seen it occur that adult children are continue to be supported well into their 20s or 30s. I've never seen that. I have seen adult children continue to receive child support into their 20s, early 20s. I have seen that. So in my experience, sometimes judges will say, if the parents can both afford it, then they will deem that the child is still a child for the purposes of calculating child support. But I've also seen judges say for the first degree only, not for the second degree. Now, that's not to say that judges can't grant child support even past the first degree, but I'm saying this just so that nobody panics and thinks automatically they'll have to pay child support into the child's adult years. It might happen, but it also might not happen. Each case is dependent on the facts within that particular case. I'll give you some examples of when I've seen judges grant adult child support under the Divorce Act for adult children. In this one particular case that I dealt with, the reason the judge, or what weighed heavily for the judge in granting adult child support, was the fact that both parents could afford it. So if both parents can afford it, they've got decent jobs, it's not going to be an undue hardship for them to pay for their children's education or to help pay for their children's education. I've definitely seen judges in that circumstance say then the adult child is going to continue to receive child support or assistance with paying for their education. I have also seen judges say that this particular rule only applies to the first degree. So it wouldn't necessarily apply for a degree past the first one. And saying all that, also just keep in mind every single case is case by case specific, so take this as general information. So I've just touched on briefly what the definition or what circumstances would arise where a child would continue receiving child support even after the age of 18 in the context of a divorce. Now I'm going to move on to those individuals that don't fall under the Divorce Act. For example, people that weren't married. For anyone else, people who either lived common law or as adult interdependent partners, or married people that don't want to pursue a claim under the Divorce Act, they're also entitled to pursue claims under the Family Law Act. They're just a bit more restricted in that they can't receive a divorce in provincial court or under the Family Law Act. But still, some parents who are in a marriage still seek remedies under the Family Law Act. So, Family Law Act of Alberta defines when a child receives child support, and it's pretty clear that they receive child support when they're under the age of 18, but when they're over the age of 18, the definition of a child that will continue receiving adult child support is as follows. They have to be at least 18, but not older than 22, and unable to withdraw from his or her parent's charge because he or she is a full-time student as determined in accordance with the prescribed guidelines. So slightly different definition than the one under the Divorce Act. Under the Family Law Act, there's actually an end date. You're not going to be able to argue for child support at age 23 or 24, for example. It will end absolutely at 22, age 22, if not age 18. So the most common reason I see for adult children to continue receiving child support is if that child is still dependent on their parent and going to school. It is pretty common that I can see that in that scenario, parents will continue to have to pay child support into that child's adult years. Not automatically, but it's a possibility. Now, before anybody starts panicking and thinking that they might be on the hook for child support for many, many more years, keep in mind that there's other factors that come into play that could come into play. For example, I have dealt with cases where the judge ordered that the child continue to receive child support even though that child was now an adult. But if you are that parent that has to pay child support for a child who's now an adult, one argument you could raise in hopes to mitigate that child support amount or reduce it is the argument that the adult child should start contributing to the costs of their own education. Obviously, the courts are not going to usually expect kids under the age of 18 to contribute in any kind of way financially to their own upkeep and education, but things change when the child turns 18. There is plenty of case law to support the position that children that are now adults must contribute towards the cost of their own education. And that is usually done through things like scholarships, bursaries, or even part-time jobs in the summer. I was able to successfully argue one particular case that the child should contribute a third of the cost of their own education. And although judges are, in my experience, not so agreeable to making the child work throughout the semester, they want the children to just focus on their studies, once it's the summertime, it kind of opens the door for that argument that the adult child should get a job in the summer and make some money to pay for something like a third of the cost of their own education or some portion of the cost of their own education, and that they should pursue scholarships and bursaries when or if they are available. Another thing I have also seen is that if there is any discord or damage in the relationship between the payor parent and the adult child, in some cases, if a lawyer or parent can show that that adult child is refusing to have a relationship with the payor parent for no good reason, sometimes that could actually lead a judge to order that child support not be paid to that adult child. So there is some case law to support the notion that if there are children that simply refuse to talk to a payor parent for no good reason, and then still expect child support, that adult child might be sorely mistaken. There are cases that have come through the courts that have terminated child support because the adult child refused to have a relationship with the payor parent for no good reason. Now, what would be a good reason for a child not to have a relationship with their parent, an adult child? Maybe there is historical abuse. Maybe there is neglect, abandonment. There might be a good reason for it. But if there's no good reason for it, let's just say the child, let's use an example. Dad is the payor and mom has primary care of the adult child, and that child is still living with mom and going to university. And let's say that child simply doesn't talk to her dad because she doesn't feel like it, because she can't be bothered to, because she's aligned with her mother and doesn't want to disturb the relationship between her and her mom. If, let's say, her and her dad had a relationship, these might be examples of not a good reason for a child not to have a relationship with the payor parent. And if that's a type of scenario that you're looking at, you might have that argument that you don't have to pay child support for an adult child that refuses to have a connection or relationship with the payor. So that is child support, adult child support in a nutshell. Of course, I could talk at more length about adult child support and how it works. And if you want more information, by all means, if you think that you might qualify for, some element of the content that I just presented, give us a call. We can do a one-on-one consultation and be more defined about whether or not any of these things that I've talked about apply to you. So just to summarize or recap this video, it covered adult child support, which, to maybe the dismay of some people, doesn't necessarily automatically end at the age of 18. Under the Divorce Act, there is no set end date for child support, although commonly, practically speaking, there is an end date, but it's not determined by statute. It's determined either by the parties themselves or by a judge if the parties aren't able to reach an agreement. And I haven't seen really any judges grant child support into the late years or their 20s or 30s. I've never seen that, but I've certainly seen judges under the Divorce Act grant child support for children in their mid-20s, let's say 25 and under. I have seen that. We also talked about the different definition, slightly different definition of for adult child support purposes under the Family Law Act of Alberta. Under that definition, there is technically an end date. It's age 22. Again, it's not automatic that you have to pay it until 22. Each case is case by case decided. Not every case is going to fall under or justify adult child support. But the point of this video is for parents to know it could go past the age of 18. Under the Provincial Act, the Family Law Act of Alberta, it will be between 18 to 22, but not past 22. And there are requirements. For example, just like under the Divorce Act, you have to show that the child is unable to withdraw from the charge of their parents. And under the provincial legislation, it specifically cites education or post-secondary as a justifiable reason to continue granting adult child support. Children who are adults, in my opinion, should start contributing to the cost of their own education through bursaries or scholarships or through part-time work. And for all those parents that are upset about the idea of paying adult child support for an ungrateful adult child that refuses to have a relationship with them for no good reason, rest assured there's also some case law that supports the idea that in that particular scenario, child support should be terminated. So hopefully you found this video informative, and hopefully it gave you a little bit more clarity on how adult child support works in Canada and specifically in Alberta. So thanks for tuning in if you're still listening to this video, and keep your eyes out for some additional videos. I've got some more ideas and want to elaborate more on other child support topics, so stay tuned. Thanks again. Bye everybody.